like a little different type of solution. A promise not to drive drunk may be enough for the court system.
Lawmakers in Washington state, they're debating changing the law that would mean repeat drunk drivers wouldn't have to put an interlock device on their car if they sign a pledge in court. Our Cor Harlan, he looked into what this means.
Well, Jennifer and Dan, I talked to two members of Mothers Against Drunk Driving today, and both of them laughed out loud when I mentioned this to them earlier this morning. This is a bill, again, that would allow some people to avoid electronic ignition locks in their cars in exchange for their promise not to drive drunk. That is, if they agree to submit to electronic alcohol use monitoring. This entire thing, believe it or not, is meant to strengthen the DUI law in Washington state, but not everyone agrees it's the best idea. Few have been affected by drunk drivers more than V. Matthews. One son, Roger, killed by a drunk driver in 1969. Another son, Blake, killed by a drunk driver in 1983 as he ran home late one night from a friend's house. It's been a long time since those two life-changing events, but V soldiers on, occasionally crying herself to sleep about it to this very day.
Actually, when I speak, I relive it all over again. I see my son dying in my arms. I see my other son laying on a stretcher at the hospital.
She now speaks to drunk drivers through victim impact panels, showing them what can happen when you drive drunk. She says she's been a supporter of ignition locking devices that are now required for people in Washington who've had 2 DUIs. What do you make of this proposal in Washington to do away with these and have people sign an affidavit saying that they promise not to drive drunk?
That promise wouldn't hold water.
Really?
Oh, no. I've been around the drunk drivers too long. And once they're drunk, they don't care. Nothing matters to them anymore.
One of the House sponsors of the bill is Washington State Representative Brad Clippert of Eastern Washington. He tells me the interlock exemption would apply mainly to people who do not possess a car after being charged. But he also tells me the exemption could be available to others as well.
I'm talking about the people that do have cars at home. They can still sign the affidavit and avoid the ignition interlock.
I suppose you could, but then they're still going to be held to the same standard. If you drive a vehicle without ignition interlock, you will be charged.
Right, okay.
And that's a gross misdemeanor for which you can do up to 364 days in jail.
Washington State is now in week 1 of its special legislative session. This is one of many topics, and I'm told very late this afternoon by a senior House Democrat that this bill is not likely to get out of the legislature alive. Jennifer and Dan?
Yeah, that's a tough one there. Your heart really goes out for V there. Thanks to her for sharing her story too, Cor.